everyone, and welcome to this video tutorial on contract terms. Today we're going to be looking at implied terms in a contract. Implied terms are words or provisions that a court assumes were intended to be included in a contract, but the terms weren't expressly stated in the contract. And in a business contract, it's usually not possible to cover every detail, and a court will often assume that some contract terms are implied. If we start by just reminding ourselves of the two different types of terms in a contract before we start, I think that would be helpful. So in our last video tutorial, we focused on express terms. So those were terms which were expressly agreed by the parties. And express terms we saw can be written into the contract, or they might be orally agreed. And what we looked at in our last video was the fact that sometimes we have difficulty distinguishing, is a pre-contractual statement a representation or is it a term? But today we're going to be having a look at implied terms. And you can see here that there are two types of implied terms for us. There are terms that are implied by the courts, and there are also terms that are implied by statute or by acts of parliament. Just to give you an idea of what these implied terms are about before we look at them in detail, firstly, implied terms by the courts. These are things that the courts think need to be implied as a matter of fact, that they are so obviously included that it didn't need to be specifically mentioned. So if, for example, I agreed to pay you £500 for a kitten, it probably wouldn't occur to us to write down that we mean £500 sterling as opposed to any other sort of pound. That's obvious to both parties. And so that's a situation where the courts might imply the term into the contract. We didn't say sterling, but it's clear that's what we meant. The other situation is where courts are implying terms as a matter of law, and that's done by statute or an act of parliament. And this is about general considerations of public policy. In this area that we're going to look at is the Consumer Rights Act, and this is where the statute creates a term that's included in all contracts regardless of the party's wishes. Things like, even if it's not expressly mentioned, goods sold must be of a satisfactory quality. They must be as described. They must be fit for purpose. Those things might not have been expressly mentioned, but nonetheless, the law is going to imply those terms into the contracts. So we're going to have a closer look at implied terms. So as I've said, what we're doing here is that we are implying a term which has not been mentioned by either party into the contract. And when you think about it, that's potentially a bit controversial, because the general rule of freedom of contract is that only parties to a contract are allowed to decide the terms of it, and they should be free to contract on whatever terms they like. And it's potentially a bit controversial if you've got a judge writing in terms that weren't agreed on that the judge thinks should be there. So we've got to be mindful of that. We're going to start by looking at terms implied by fact. And the first case that we've got here is the case of Marks and Spencer and Paribas. It's a very important Supreme Court decision on implied terms, and the case was actually about a dispute between Marks and Spencer's and their landlord, Paribas. And Marks and Spencer's wanted to stop leasing part of their building before the lease was due to end. And the case hung on an issue of an implied term in the landlord and tenant lease. What's really important about this case for us is that the Supreme Court stressed that courts would only imply a term into a contract if it was needed for business efficacy. And they approved the officious bystander test from an earlier case of share law, which we're going to look at shortly. So the Supreme Court here was really stressing that courts should only be implying terms where it's really necessary to do so. So in that way, they were showing that they wanted to respect freedom of contract, and they wanted to make sure that they were only implying terms based on the imputed intention of the parties. In Marks and Spencer, the Supreme Court approved the test used in the earlier case of Share Law and Southern Foundries. And this case from 1939 gives us what we call the officious bystander test. The officious bystander test for implying a term by fact is that if a third party was with the parties at the time the contract was made, and had they suggested the term should be implied, it would be obvious that both parties would reply with a hearty, "Oh, of course." And what this test really means is that the courts will only imply a term into the contract if it is obvious that both parties would agree to the term at the time the contract was made. i.e., courts can't be implying terms after the event that wouldn't have been agreed to by the parties themselves at the time. The test that was referred to by the Supreme Court in the Marks and Spencer's case is the business efficacy test, and this is still on the same point on when a court's going to imply terms by fact. And the business efficacy test asks whether the term was necessary to give the contract business efficacy, i.e., would the contract make business sense without it? And the courts will only imply a term where it is necessary to do so. The test comes from an ancient case called the Moorcock, and in this case the claimant moored his ship at the defendant's wharf on the River Thames. The River Thames is a tidal river, and at times when the tide went out, the ship would come into contact with the riverbed. And the ship actually became damaged due to uneven surfaces and rocks on the riverbed. And the claimant sought to claim damages from the defendant, but the defendant argued that there was no provision in their contract warranting the condition of the riverbed. But the court implied a term in fact, and they implied that the riverbed would be safe for mooring. And when they implied this term, the court introduced the business efficacy test and said that this term, the dock would be safe for mooring, was necessary to give the contract business effect. And if the contract makes business sense without the term, the courts will not imply it. But in their mind, this contract would not have made business sense without the term that the dock would have been safe. So we've looked at the first type of implied terms then, i.e. terms implied by fact. Let's go on to consider the second type of implied terms, which are terms implied by law. And specifically, we're going to be looking at the Consumer Rights Act here. And the Consumer Rights Act implies terms into contracts regardless of the parties' wishes, in order to protect consumers against unfair terms, preventing companies excluding liability for negligence, and also to ensure that things automatically go into consumer contracts which are necessary, such as goods being of satisfactory quality. Consumer Rights Act 2015 applies to all contracts between traders and consumers. And on this slide, I've summarised some of the key provisions from the Consumer Rights Act, and these are all terms which are implied into the contracts regardless of the parties' wishes. If we have a look at some of these then, Section 9 says that all goods must be of satisfactory quality. So regardless of what the parties themselves have said, the Consumer Rights Act 2015, implies a term that all goods will be satisfactory quality. All goods under Section 10 must be fit for purpose. All goods under Section 11 must be as described. This act, you can see, as well as looking at supply of goods, it also looks at supply of services. So if, for example, you've got a plumber or a builder come into your house, regardless of what your contract says with that plumber or with that builder, there are these certain terms which are implied by the Consumer Rights Act. So Section 49, for example, says that the plumber must use reasonable care and skill when carrying out the work. Section 51, there must be a reasonable price. Section 52, it must take a reasonable time scale must be involved. Obviously, the word reasonable is subjective, and open to interpretation, but that's obviously so that it can cover lots of different situations. The Consumer Rights Act also regulates unfair terms. So Section 62 says that any terms which are unfair in a contract are not binding on the consumer. And in this way, you can see that the Consumer Rights Act is trying to give some balance, some redress to the weaker party in a contract, because usually your consumer is going to be the weaker party. So it's about addressing that balance in bargaining power. Section 65 is quite important for us because it implies a term that a contract cannot restrict liability for death or serious injury caused by negligence. So if, for example, Liam has a contract to put in a new boiler in someone's house, and in his contract it says, I won't be held liable if everyone dies of carbon monoxide poisoning if I put this in wrong. He's written that into the contract. Even if his customer signs it, the Consumer Rights Act 2015, Schedule 65, will strike that out. He cannot restrict liability for death or serious injury caused by negligence. And there is some guidance in Schedule 2 of the Act, a sort of grey list, if you like, of the sorts of terms that might be seen as being unfair on consumers. So when you're looking at a contract, you've got to think about, is it unfair? If it's a particularly harsh term, it should be very prominent, clearly pointed out in the contract. You've got to think to yourself, is it unusual? Is it something you would not expect to be in that sort of a contract? If it is, it might be that it's an unfair term and it won't be binding. You also need to be aware of the Consumer Contracts Information Cancellation and Additional Charges Regulations of 2013. Catchy little number there. This is quite important. I'm sure you'll be aware of this law, even if you didn't know its name, because these regulations give customers the right to cancel a purchase agreement 14 days from the day the goods are received. So I'm sure you all know that, if you receive something, you order something on Amazon, you've got 14 days to return it if you're not satisfied with it. And that's under those regulations. To summarise on implied terms then, what we've seen is that implied terms can be implied by fact or they can be implied by law. And when we're looking at terms implied by fact, this is where the courts or the judges are implying a term for business efficacy. And in Marks and Spencer, that very important Supreme Court case, the court stressed that they would only imply a term into a contract if it was necessary for business efficacy. And they also approved the case of share law. Share law, if you remember, gave us the officious bystander test. And this is a test which says that the courts can imply a term if it's clear that both parties would have agreed to that term at the time that the contract was made. Business efficacy came from the case of the Moorcock, and that was where the term has to be in there, basically for the business contract to function. And the final type of implied terms are terms which are implied by law or implied by statute. And we had a look at the Consumer Rights Act 2015 on that. And remember that what this act does is that regardless of what the parties would like, or regardless of what the parties have said in their contract, there are certain terms that will be implied into every consumer contract. Things such as it being fit for purpose, satisfactory quality, but also to be mindful of unfair terms won't be binding, and you can't restrict liability for death or serious injury caused by negligence. So that's implied terms then. Please watch the next video tutorial in which we'll be looking at exclusion clauses.